Hello, you're welcome to Law Minstrel. I am Mwese Modukbe Nyim. Today on this episode, we'll be looking at a contract of sale of goods as distinguished from other similar transactions. You recall that we already did an episode fully on sale of goods. So on this episode, we'll be trying to do a distinction between sale and other similar transactions. And we have quite a number of transactions that are very similar to sale of goods, but they are not. And it's important that you know the distinction of sale from these transactions, because since they look like a sale, you may mistake them for a sale, whereas they are not. Why is it important for you to be able to do this distinction? If you are a law student, for instance, it's important for you to know this distinction, because when problem questions are set, this could be a very good area to set a problem question. The problem question will come in a way that the transaction being portrayed in that problem question may look very similar deliberately to a sale of goods. And if you have not familiarized yourself very adequately with what a contract of sale is, you may be quick to answer the question as though it is a contract of sale, whereas it is not. If it is merely a problem that encounters you as a student, that may even be fair enough. But when you now become a lawyer and you have not mastered the difference, your problem questions will now be cases that clients bring to you. If you have not mastered the difference, you will run ahead thinking that this situation that your client brought to you is a sale, and you'll be bringing solutions that should be for a sale to the client's situation, and it may just not profile the solution that your client needs. And so it's important, whether you are a lawyer, whether you are a law student, or whether you are just someone that is engaging in any of these transactions, you intend to engage in a contract of sale, you should know when what the other party is offering you merely looks like a sale, but it is not. It's alright. So these similar transactions that we'll be examining on this episode, which look like a sale but are not a sale, are about 9 in number. We would therefore be examining the distinction between sale and exchange. Then we'll examine the distinction between sale and payment. Then we'll examine the distinction between sale and hire purchase. Then we'll examine the difference between sale and a gift. Then we'll look at the difference between sale and agency. After that, we'll look at the difference between a sale and mortgage. Then we'll look at the difference between a sale and supply of services. Then we'll now proceed to look at the difference between sale and loan on security. And finally, we'll look at the difference between sale and an agreement to sell. Thank you. I'll just pause here and inquire from you if you have become a member of our community yet. If you have not, I enjoin you to kindly do so by simply clicking on the subscribe button. That will make you automatically subscribe to our channel, and it will enable you to get all of our videos as they drop. And in the event that we have an opportunity just designated to members of our community, you'll be entitled to it simply as a member of our community. And I also enjoin you, if you have enjoyed our videos, kindly share to your loved ones, members of your sphere of influence, and also to give us a thumb up by way of encouragement, and drop in the comment section if that's not too much to ask. I would read them, and if I need to make a response to them, I would do so. Thank you so very much. So we'll go into our business on this episode, which is doing the distinction between sale and other similar transactions. So a contract of sale may be similar to many other contractual transactions, but not akin to them. In this context, therefore, a contract of sale is distinguished from other commercial transactions in this section. Do you know that even human beings usually look similar to people, but they are not? Like many a times when I go out or I go to functions, I meet people telling me, please, are you related to so and so person? Or they begin to talk to me as if I were somebody. And so I've come to realize that I look like so many people to people. So if somebody just goes to go and engage me on something that is not me, is merely someone that looks like me, and the person does that engagement for a long stretch of time, and if property is even supposed to transfer and the property transfers to me and it was not supposed to have been me, you know that person is going to suffer a lot of loss. So in transactions as well, this transaction of sale may look similar to this other transaction, but because it is not, there is not akin to them. If you engage in another transaction thinking that it was a sale whereas it was not, you may end up having your fingers burnt or suffering some form of damage or some form of loss. It's okay. So we are going to begin by looking at one such transaction which is similar to sale but is not, and that transaction is the transaction of exchange. So we are looking at the distinction between a sale and an exchange. So a contract of sale is actually distinguished from an exchange or a barter by the statutory requirement of monetary consideration under section 1(1) of the Nigerian and UK SGA. So whereas an exchange involves a transfer of goods in return for other goods. So you see that this is a clear distinction. In a contract of sale of goods, somebody gives you a good and you in turn gives that person money. In a transaction of exchange, somebody gives you a good, quite alright, but instead of giving that person in turn some money, you now give the person some other good in exchange for that good. That is what is meant by an exchange. And another name for that is actually barter. It's okay. So you will see that in Aldridge versus Johnson, a contract for the exchange of 52 bullocks with 100 quarters of barley, the difference in value to be made up in money was treated without more as a contract of sale. You remember, if you have watched our contract of sale, we said that in a sale you can make payment of part money and part something else. But where it is wholly something else and not money, you are exchanging for, you are giving in exchange for goods. If it's wholly something else, not money, then it is not a sale, it's actually an exchange. Another name for this exchange could be barter, and so that's why you hear the expression trade by barter. So we'll look also at the distinction between a sale and bailment. So a bailment is actually a transaction under which goods are delivered by one party known as the bailor to another party who is called the bailee on certain specified terms. So these terms usually provide that the bailee is to have possession of the goods and subsequently redeliver them to the bailor in accordance with the instruction. So the property in the goods is not intended to and does not usually pass on delivery, and in fact remains with the person who is called a bailor. So though it may sometimes be the intention of the parties that it should pass in due course, as in the case of ordinary hire purchase contract, but in ordinary sense, in a bail transaction, the bailee will take possession, but the property in the goods is not intended to pass. It stays with the person that is called a bailor. So In a contract of sale, however, there is usually an indication that the property in the goods will pass to the other party called the buyer in that transaction. In other words, in a contract of bailment, there is no transfer of property in the goods from the bailor to the bailee, whereas in the case of a sale, there's a transfer of the property in the goods from the seller to the buyer. Thank you. With this, we'll now move to the distinction between a sale and a hire purchase. So a contract of hire purchase resembles a contract of sale in so very great measure. So in fact, in virtually all cases of hire purchase, the ultimate intention of the party who engages in that hire purchase with the owner of the subject matter of the hire purchase is that the property in the goods should eventually transfer to him, who is the hirer, at the end of that transaction. So in essence, at the end of that transaction, the hirer would exercise what is called the right of purchase. So it's like an aspect of hire purchase has something that looks like a sale also actually. So it is for this reason that a distinction between a sale and a hire purchase becomes necessary for you to know the distinction from the outset. So whereas a contract of sale involves the two parties being the buyer and the seller, a hire purchase contract may involve more than two parties, although sometimes it may involve only two parties as well. But it may involve more than two parties. It may involve three parties, where there is an owner of the goods who sells them to a finance company, and then this finance company in turn leaves the goods on hire purchase terms to a hirer, who may only become the buyer where he makes the last installment and exercises that option of purchase that he has as a right. Thus, under a hire purchase transaction, the hirer, who may or may not become the buyer, has possession of the goods and is entitled to the use of the goods. Although he is not the owner and he has no relationship per se with the seller, where the parties are three. So now, but you will see that in a contract of sale, that sale is done outrightly. In a contract of hire purchase, a sale may come, but it comes at the end of a hire. In a contract of sale, stricto sensu, there is no hire at all attached thereto. So we'll now go to the distinction between a sale and a gift. So a gift appears clearly distinguishable actually from a sale, as it is a voluntary and gratuitous transfer of the property in a good from one person to another at no consideration at all. So in sum, a gift is a transfer of a property without any consideration furnished, whereas in a sale there is a consideration. There is a transfer of goods from one person to the other, but the other who is now receiving that transfer in the goods is now making a consideration of money. It's all right. So that's the main distinction between a gift and a sale. So where a transaction in which what is supposedly a free gift is offered as a condition of entering into some other transaction, the distinction may no longer be so clear. So in Esso Petroleum Limited versus Commissioners of Customs and Excise, garages selling petrol advertised a free gift of a coin bearing the likeness of a footballer to anyone who bought 4 gallons. So the House of Lords held that though the transaction was not a gift, as the garage was contractually bound to supply the coin to anyone buying 4 gallons of fuel, it was equally not a sale of goods. So the transaction was thus held as a collateral contract existing alongside the contract of the sale of the petrol. So we'll now move from there to the distinction between sale and agency. So in a contract of agency, there exists privity of contract between the buyer and the agent supplier. Now which will a locus for action to be brought between them. Now but where there is a sale, there exists no privity between the buyer and the seller's own supplier. Generally, the duties of a commission agent are not as stringent as those of a seller, and this consequently reflects on the measure of damages in the event of a breach of that contract. For instance, where a seller supplies less than he is obligated to supply under the contract, the buyer may reject the whole. Whereas if a commission agent delivers less than what the principal has ordered, he has committed no breach of contract and the principal is bound to accept whatever is delivered to him. Where an agent supplies goods of lesser quality than what his principal ordered, he will only have to pay damages for the actual loss suffered by the buyer. But where a seller is guilty of a similar breach, he may be liable to pay damages for the buyer's probable loss of profit as well. We'll now look at the distinction between a contract of sale and a mortgage. So whereas a contract of sale transfers the property in the goods from the seller to the buyer at the completion of that contract, a mortgage transfers the property in the goods from a mortgagor to a mortgagee merely to secure a loan. So immediately that loan is repaid, the property will transfer back to the owner of the property. So the mortgagor retains the equity of redemption by which he may redeem his property upon the payment of that loan. We'll now look at the distinction between sale and supply of services. So contract for supply of services are classified mainly into two. One, contracts for skill and labor, and the other, contracts for labor, work and material. Okay. In either case, whether it is contracts for skill of labor or it is contracts for labor, work and material, relevant law is not the sale of goods law. So the contract for supply of services is not governed by the sales of goods law or sales of goods act. So you will know that automatically means that these two contracts are actually not the same. So an example is where you engage the services of an artist. For instance, where you contract an artist to make you a portrait, you will actually pay for the said services and he will in turn give you the portrait upon having made your portrait. So the portrait return is only incidental to the services for which you have paid. So it's not like you have bought goods per se. So the question therefore arises, is a contract in which one party is to produce, make, manufacture goods and then supply them as finished products, contract in sale of goods, or is it a contract for services as well? It is imperative that this question is settled, since the provision of the Sale of Goods Act do not generally apply to contract of services. Now again, the implied duties of the seller in the case of contract of sale are different from the implied duties of a service provider under a contract of skill and labor or contract for labor, work and material. In the case of the former, it is of a matter of strict liability. In other words, the seller is responsible for defects in the goods, even if negligence cannot be established. In the case of the latter, however, the supplier or service provider's duties are essentially the duty of care or of reasonable care. In the case of Robinson versus Graves, the court set out the test for deciding whether a contract falls into the category of a sale or into the category of a service, which is an inquiry as to the substance of that contract. In that case, the contract was one under which an artist agreed to paint a portrait of his client's wife. The transaction was held as one for services. The court arrived at this holding by inquiring into the substance of the contract. the court held per L.G. Greer that if the substance of the contract is that skill and labor have to be exercised for the production of the article, and it is only ancillary to that there will pass from the artist to his client or customer some material in addition to the skill involved in the production of the portrait, that does not make any difference to the result, because the substance of the contract is the skill and the experience of the artist in producing the picture. In sum, where the substance of the contract is the skill and the labor of the supplier, the contract is one for services. But where the real substance of the contract is goods to be provided, then the contract is one of sale of goods. With this, we will now look at the distinction between sale and a loan on security. What's the difference between sale and a loan on security? Loan on security is a transaction that is designed to enable someone, e.g., X, who owns the property in some goods, to borrow money from maybe Y, and give possession of those goods to Y, the money lender, as a sort of lien or collateral. So the goods can only be reclaimed upon completion of repaying that loan. This transaction does not mean that the person borrowing money has delivered the goods to the money lender, but only delivers the goods to the money lender to hold as a mere security. In these contractual relations, you will see that X has not sold the goods to Y, and thus the property in the goods does not vest in Y. That property does not pass from X to Y because Y has not bought the goods. He only holds them as a form of security or collateral for the loan in issue. Upon the repayment of the said loan by X, as well as the interest, if any interest accrued, the goods will revert back to X, who is actually the owner of the goods. So the lender has no right at all to resell those goods unless the borrower has defaulted in the repayment. So this form of contract, unlike sale, does not contemplate to divest the owner of the property in the goods and then vest the said property in the person that was giving out the money, as though the person has bought the said property. In this wise, therefore, the lender, having no ownership in the goods, cannot transfer them to a third party except where the borrower now defaulted in repayment. We'll now look at sale and agreement to sell. We'll look at sale and agreement to sell, which is the final thing that we are looking at. A contract of sale has been said to be a generic term, and this generic term includes both an actual sale, where the ownership in the goods passes to the buyer immediately when the contract has been made, and an agreement to sell, where the ownership in the goods is to pass subsequent to the making of the contract. So the salient grounds of differing between a sale and an agreement to sell are thus discussed as follows. In the first instance, where the property in the goods passes from the seller to the buyer at the time of the making of the contract, that contract is an outright sale. Whereas if the property in the good does not pass at the time of the making of that contract, but we pass at some future time or upon the happening of a certain condition, it is not an outright sale, it is an agreement to sell. So the import of this is that where it is a sale, the buyer becomes vested with the property in the goods at the time of the making of the contract, which means that immediately the contract is made, the buyer becomes the owner of the goods immediately. Whereas in an agreement to sell, the buyer in that transaction will become vested with that property or become the owner of that property at a future day, not immediately. So this is the distinction between a contract of sale and a contract that is merely an agreement to sell. So where after making the contract there is a loss or damage to the goods, who bears the loss to the goods? This also serves as a distinction. So generally, goods are the risk of the person who is either their owner at the material time in question. So if it is in a case of sale, you see that we have already said that immediately after the contract is done, the ownership will change. The buyer will now have the ownership. So when the buyer now takes ownership and then the goods now damages, then he's the one that is going to take liability, because he has actually become an immediate owner of the goods. So in this regard, where it is the case of sale and the ownership in the goods has passed to the buyer already, the goods become at his own risk. They are no longer at the risk of the seller. Therefore, the loss to the goods will be borne by him and not borne by the seller. But where it is an agreement to sell, when the good will still be at the risk of the seller, because the property in the goods has not yet shifted to the buyer. So it is the owner of the good, it is the person who retains property in the goods that bears the risk to the goods. So where losses occurs when the seller is still the owner of the goods, he still bears the loss and the risk of those goods. Thus, the loss will be borne by him. So again, under a contract of sale, since the property in the goods has passed to the buyer, where he fails, refuses or neglects to pay the contractual price or consideration, the seller is at liberty to sue for the price of the goods. So whereas in an agreement to sell, since the ownership of the goods still resides with the seller, he may only sue him for damages for non-acceptance. He cannot sue for profit. Now finally, sale is an executed contract, since it encapsulates a contract as well as a conveyance. An agreement to sell, on the other hand, is an executor contract, since it is merely a contract and does not include a conveyance therein. Thus, in a case of sale where the seller breaches the terms of the contract by supplying the goods to another person who is a third party, the buyer is at liberty to sue the seller for the breach of a contract as well as for the tort of conversion and detinue. Since the buyer has also a right in rem in case of sale, he may follow the goods into the hands of third parties. Whereas in a mere agreement to sell, where the seller breaches his agreement to sell to the buyer has merely a right in personam, not a right in rem, and can only obtain a personal remedy against a seller, not a third party. We've come to the end of this distinction, but I wish to say to you that in the event that you had not watched the episode on what a contract of sale is and then you came to watch this distinction, it will do you a whole lot of good to go back and watch the video on contract of sale before you begin to look at the other contracts that are similar to it and are not actually sale. And then if I'm beginning to mention things that relate to right in rem and right in personal and you do not really understand what that means, I will refer you to our video, which is one of the series on the the legal terms that are relevant to nurses, and we took time to explain what rights are. You will be able to understand clearly what a right in rem is as well as what a right in personal means. Now with this, we have come to the end of this episode. Now we'll do a run through on what we have done and then we'll wrap up on this episode. We actually did a distinction between sale and other similar transactions, and in so doing we looked at 9 of such transactions that are very similar to sale but are not. The first that we looked at was exchange. So we looked at the distinction between sale and exchange. After that, we did a distinction between sale and payment. Then we did a distinction between sale and hire purchase. After that, we did a distinction between sale and gift. then we did a distinction between sale and agency, and then we did a distinction between sale and mortgage, after which we looked at the distinction between sale and supply of services, and then we looked at the distinction between sale and loan on security. Then we finally looked at the distinction between sale and an agreement to sell. With this, we've come to the end of this episode. I hope that you enjoyed this episode as much as we did enjoy bringing it to you. If you did so, kindly give us a like by clicking on the like icon, and also share with your loved ones or other persons within your sphere of influence. And then you're not a member of our community, please do so by clicking on the subscribe button, and you immediately be subscribed to our channel. You have anything you want to say to us, kindly do so in the comment section. Till next time, I am